Professor Laura, it's a great pleasure to have you here to learn and hear from you today on the issue of the binding treaty on businesses and human rights and expected outcomes. My name is Victoria, and here as organizers, we have Daniela and João, and also as debaters, we have Professor Julia and Bruna. So just to present our initiative, the University of São Paulo Businesses and Human Rights Working Group is a group of academics coordinated by Professor Eduardo Sá-Diniz, whose purpose is to analyze the current trending regarding business misconduct and human rights. Through the webinars, we seek to address the problems caused and increased by the COVID-19 with particular gravity in Brazil, as I imagine everyone has been following these days. We are also grateful for our colleagues from outside Brazil for their prestige with our webinar, as well as solidarity above all with our current scenario. For those who cannot watch now, our webinar is gonna be recorded and will be available on YouTube. Laura Iñigo is a professor and postdoctoral researcher in international law at the Nova School of Law, as well as research assistant at the Nova Center of Businesses, Human Rights, and Environment. Professor Laura is also a main reference in international debates on the expected treaty on businesses and human rights. So without any further ado, I am gonna hand over to Professor Laura to present the topic and her considerations. And if you prefer, we can start with your presentation. And after that, our debaters bring their own remarks, Professor. Thank you.
Good afternoon, everybody. I would like to first thank the organizers of this webinar for the invitation, to Professor Eduardo Sá-Diniz, the members of the working group, Victoria, Daniela, and João, and also the commentators today, Julia Gracia and Bruna Santos. So thank you for having me. And this is actually the first time that I participate in a Brazilian webinar. And I really hope in the future we can do this in person when everything gets better, hopefully. So today I would like to talk about the initiative of the Binding Treaty on Business and Human Rights, its process, and some of the main challenges, but also some positive aspects. I'm gonna share my screen. Please, João, tell me if everything works.
Okay, Professor.
Is it working?
Yes, perfectly.
Okay. So
Yes.
there have been many debates on whether this treaty was desirable or not, whether it was feasible, and lately the discussion has looked at the specific content of the treaty and which elements should be included. The general idea is that a binding treaty on business and human rights would contribute to greater accountability of companies, and in particular of transnational corporations in relation to human rights abuses, both in terms of prevention and also for securing effective remedies for victims. But before going into that, I would like to examine a bit of the background regarding the drafting process of this instrument and previous initiative. So for the purpose of clarity, I have added a short outline about the different issues I will discuss today. Starting with the background of previous initiatives, the timeline of events regarding the current draft treaty, some aspects of the content of the draft treaty, then looking at the potential benefits of a binding treaty, and finally, the main legal and political challenges. So starting with a bit of the background, over the past decades, there have been several attempts to develop global standards to hold companies accountable for their involvement in human rights abuses. From the late 70s until the beginning of 2000, there was at least three main initiatives each of them with their own modalities. These were the OECD guidelines for multinational enterprises, the UN Global Compact, and the draft norms on the responsibilities of transnational corporations and other business enterprises. The OECD guidelines were adopted in 1976 and provide voluntary principles and standards for responsible business conduct. And they are recommendations addressed by governments to multinational enterprises operating in or from adhering countries. And the guidelines were revised in 2000 and then in 2011, including a chapter on human rights. And most importantly, they come with a system of national contact points that can receive complaints in relation to the implementation of the guidelines. Then in 1999, the UN Secretary General Kofi Annan launched the UN Global Compact as a voluntary initiative aiming to align business operations with the so-called 10 principles, which consider issues such as human rights, labor, environment, and anti-corruption. But as a voluntary instrument, the Global Compact lacks the means of enforcing its principles. And after that, one of the first attempts of adopting a binding instrument on business and human rights was made in 2003 with the draft norms on the responsibilities of transnational corporations. And the draft norms try to address the inadequacy of the traditional state-centric approach to regulating corporate behavior in the era of globalization. They were drafted after 4 years of consultations. And as civil society organizations strongly endorsed the norms, but the reactions of businesses was largely hostile, and many governments were also uncomfortable with the document. There were strong pressures from business actors such as the International Organizations of Employers and the International Chamber of Commerce. And most criticism related to the fact that the norms fail to clearly distinguish between the human rights obligations of states and the responsibilities of companies. And others argue that international human rights law could only be applicable to states, so rejecting the idea that businesses could have human rights obligations. And then, due to the lack of support of the UN draft norms in 2005, the UN Secretary General appointed Professor John Ruggie, as you know, as the Special Representative on Business and Human Rights, with the mandate to propose measures to strengthen the human rights performance of the business sector around the world. He conducted several consultation processes on 5 continents and with different stakeholders, including businesses, governments, and civil society organizations. And as you know, the end result was the UN Guiding Principles on Business and Human Rights, based on the 3 pillars: protect, respect, and remedy, which were unanimously endorsed by the Human Rights Council in 2011. And today we can say that the UN Guiding Principles constitute the most authoritative international standard regarding business and human rights. And this year actually marks the 10th year anniversary of the UN Guiding Principles. So as we see so far, the preferred approach has been based on soft law, consisting of voluntary guidelines for businesses, with the most notable example being the UN Guiding Principles. However, while such voluntary commitments are clearly useful, a stronger set of norms is required to establish a clear accountability process for the human rights violations committed by transnational corporations. The non-binding character of the UN Guiding Principle has been portrayed as a particular weakness, and in fact, some governments and civil society organizations have also pointed out the limits of the voluntary initiatives. So that is why, led by the proposal of Ecuador and South Africa in 2014, the UN Human Rights Council established an open-ended intergovernmental working group with the mandate to elaborate an international legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business enterprises. And here it is important to remember that when in September 2013, Ecuador proposed the creation of a working group to negotiate a binding treaty, the support from the members of the UN Human Rights Council was moderate. Ecuador resolution in 2014, co-sponsored with South Africa, was adopted with only 20 votes in favor, 14 against, and 13 abstentions. It was rejected by the industrialized members, including the UN member states, sitting on the UN Human Rights Council, while most Latin American members opted for the abstention, including Brazil as well. Since the creation of this open-ended intergovernmental working group, there have been 6 sessions and 4 draft documents have been published. In October 2017, the chair of the working group published a guiding document entitled Elements for the Draft Binding Treaty. And this document was considered as the basis for the substantive negotiations to elaborate the treaty. And it was made with the idea to reflect the inputs provided from states and other relevant stakeholders in relation to the content, the nature, and the form of the future instrument. Then in July 2018, we have the zero draft that was published. And this zero draft was considered by some scholars, such as Professor Nadia Bernatz, as the triumph of realism over idealism, because the core of the draft included neither direct corporate human rights obligations nor corporate criminal responsibility under international law. And then in July 2019, the first draft was published. Overall, the 2019 draft version was clearer and more precise than the previous versions, and there were also references to international crimes in Article 6 about legal liability. And then last year, in August 2020, the second revised draft treaty was released, and the reactions to this second draft from scholars and from other advocates were generally positive, although there are still a number of issues that remain controversial. Also, while the new draft did not make substantive revisions to the 2019 draft, it could be seen as a positive step that contained welcome improvements to the text, as I will mention later. And then the next session of the working group will be on October of this year, the 7th session, where the third revised draft treaty is expected to be discussed. So this is more or less the state of the discussions about the draft treaty. And then from the point of view of the content of the treaty and in terms of human rights protections, and the most important aspect is whether the text of the treaty will serve to fill major gaps in ensuring prevention of corporate human rights abuses and providing access to justice and reparations for victims of such abuses. Overall, it has been argued that the second draft treaty seems to be going in the right direction, although there are a number of questions that require further attention. In general, then the new text adds clarity and more cohesion, and is better aligned with the UN guiding principles. I will not comment on the whole text, but on particular aspects of it, looking at the latest version. So, for instance, in relation to the definitions in Article 1, the term victims is more comprehensive in this second draft and corresponds to the definition accepted in international law. It is also welcome that the notion of business activities makes explicit reference to state-owned enterprises, something that has been now included. And although the new draft takes back to the term human rights abuse and does not make references to human rights violations and abuses, which would be actually preferred in my opinion. And then in terms of the scope of the treaty, there was a previous deadlock on which business enterprises should be considered, should be covered. And now the draft treaty mentions all business enterprises and makes a specific reference to transnational corporations. Another significant addition is that when imposing prevention obligations, Article 3 gives states the possibility to differentiate business enterprises based on their size, sector, operational context, and the severity of impacts of human rights as to how they discharge their prevention obligations. And then I would say another important aspect, it's about the list of human rights that are covered. Now there is a more complete statement regarding the coverage of all human rights, making reference to the Universal Declaration of Human Rights, customary international law, and any core international human rights treaty and fundamental ILO convention. These represent a more comprehensive definition on the scope of human rights cover, although some scholars and civil society organizations have proposed to include references to specific instruments such as the ILO Declaration on Fundamental Principles and Rights at Work, or the Rio Declaration on Environment and Development. Then going into the rights of victims, Article 4 stresses some of the key rights of victims in line with the UN Basic Principles and Guidelines on the right to a remedy and reparation for victims. So the treaty is not inventing or creating new rights for victims of corporate abuse. It is just emphasizing some of the key rights. And it's also welcomed the reference to the protection of human rights and environmental defenders in Article 5. Although it would be desirable to include a statement to ensure that enterprises do not intimidate or harass human rights defenders due to the continued threats that they face by businesses. Another recommendation could be to include specific references to the differentiated impacts of human rights abuses on women, children, migrants, indigenous peoples. That would be also desirable because of the distinct impact of these abuses on such groups. Then going into the prevention and the human rights due diligence, Article 6 seems now to be more aligned with the 4 steps of human rights due diligence process established in the UN Guiding Principles. And as you maybe know, these 4 steps are the first is identifying and assessing actual and potential human rights impacts, integrating and acting upon the findings. Then the third step, tracking responses, and the last one, communicating and reporting on how the impacts are addressed. So these are some positive developments in the provision of the second draft treaty. On the contrary, improvements are mainly required in relation to the provisions on legal liability and access to an effective remedy in Articles 7 and 8. These provisions were already the object of discrepancies from business advocates and states, and it seems that they will remain the subject of discussion in the following versions because these represent the core provisions of the treaty. In terms of legal liability, Article 8 should better clarify between provisions addressing, on the one hand, liability in cases of harm caused or contributed by a company's own activities and operations, and on the other hand, liability in cases of harm caused or contributed by the activities or operations of a company that it controls, or failure to prevent harm directly linked to its business relationships. So there is a need for some clarifications in relation to the definition of control or overall control over the parent company. And also Article 8 has eliminated the list of criminal offenses that was included in the previous draft. The previous draft contained a detailed list of criminal offenses which did not count with general agreements among the different stakeholders. The current draft aims to build a political consensus by overcoming these objections. However, as some scholars have argued, this change may not be serve the purpose of bringing more clarity and legal certainty. So consequently, including an illustrative list of widely accepted offenses under international law will provide better guidance for both states and businesses. And then finally, I want to mention the provisions on access to an effective remedy. And there are a number of provisions requiring states to remove barriers faced by victims of business-related human rights abuses. I would say access to information should be strengthened in order to allow victims to seek information from both states and businesses. And also, the text refers to the possibility of obtaining remedies through both judicial and non-judicial remedies, but states-based non-judicial remedies. And I think this is key since non-judicial remedies could play a vital role in providing remedies to victims and could represent more accessible and affordable mechanisms, although they should serve to complement or supplement judicial remedies. I will skip the part on armed conflicts, but overall, the draft treaty tends to focus mostly on the obligations of states and not as much on those of businesses, following the language of the UN guiding principles. And the other issue that I want to address is about the potential benefits of a binding instrument on business and human rights. And here there are several reasons. And I would say first, adopting a binding treaty would be important for establishing direct human rights obligations for corporations. And here, the fact that the human rights discourse was initially focused on governments does not mean that governments are the only agents upon whom obligations fall to realize these entitlements. Entities other than states, or also called non-state actors, can and should bear some minimum obligations flowing from human rights. And the basis will be the human rights dignity of individuals. And this can also be seen in the preamble of the Universal Declaration of Human Rights that refers to every individual and every organ of society. It has been often suggested by some authors that there is a danger in the proposed extension of human rights obligations to corporations of undermining the responsibilities of state actors. However, As was already explained by Professor Andrew Clapham, non-state actors, and in particular corporations, could have human rights obligations in a way that complements the responsibilities of states rather than replacing such obligations. So a key role for an international binding instrument would be to expressly recognize and clarify that business enterprises have legal obligations flowing from international human rights law. Secondly, I would say that establishing corporate accountability for human rights abuses is also required by the rule of law principle. And the rule of law refers to a principle of governance in which all persons, institutions, and entities, public and private, are accountable to the law. And in particular, this principle requires equality before the law, accountability to the law, and legal certainty. So having a binding instrument would also serve the purposes of legal certainty. Even if we recognize that corporations have certain human rights obligations, questions remain concerning the exact nature and extent of these obligations. Consequently, a binding treaty could serve to specify the exact obligations of businesses in relation to human rights. And moreover, I would say that a binding treaty could also serve as a unified instrument, considering the existing of a fragmented landscape with sectorial norms, regional norms, and soft law instruments. And then thirdly, I would say that this would be a normative development that is in accordance with previous instruments and relevant international and national practice. So this would not be a radical new idea. For instance, if we look at the UN Basic Principles and Guidelines on the right to remedy and reparation, it states that a person, a legal person or other entity could be found liable for reparation to a victim. And this is also emphasized in the commentary to the principles by the former rapporteur Van Boven. There are also general comments from human rights body recognizing the responsibilities of corporations, although in an indirect manner. For instance, the general comment 14, 18, and 24 from the Committee on Economic, Social, and Cultural Rights, referring to the responsibilities of the private business sectors in relation to the right to health or the right to work. And there are also reports from special rapporteurs and independent experts who has emphasized that non-state actors do have minimum set of obligations under international humanitarian law and human rights law. And finally, also the own practice from national courts when they have been dealing with abuses committed by corporations. So the binding treaty would be the logical next step in this process of normative development. However, we cannot forget what could be the legal and political challenges, this is an important part of this process. For the political challenges, it's well known that so far there has been limited amount of negotiation among a critical mass of states, with some of what has taken place in backdoors or through proxy states. The lack of political will among key countries, including the European Union and other states in the Western Europe, is still a major obstacle to progress in this area. Many states are concerned of the legal and diplomatic viability of the treaty, and now the EU is also busy with the adoption of the directive on mandatory human rights due diligence. Also, the treaty process, and in particular human rights treaty process, is a long and complex path, and it could also fail if it does not come with sufficient support. And then for the legal challenges, the current draft requires more legal clarity. More clarifications are needed in terms of what human rights are covered and whether there are human rights that should be specifically addressed, what type of abuses are covered and why they are not addressed as violations, what type of involvement is required from the parent company, how shared responsibility will be established, etc. And another issue would be the lack of enforcement at the international level. So far, the enforcement is based on the domestic level. And there have been some suggestions to give a committee that is envisaged in the draft treaty to have a mandate to accept complaints and make recommendations about emblematic or selected cases or systematic abuses. However, this has not been included in the draft. But I would say the main challenge is finding a balance between a very comprehensive and very ambitious text that would be difficult to get the sufficient state support, and a very narrow and a specific treaty which do not actually serve to fill major accountability gaps in international law. And it could be just a repetition of what previous soft law instruments have said. So this would be my overview of the initiative of the binding treaty. So
Thank you very much, Professor. It was a very rich presentation with very challenging considerations on the international dynamics of conceiving an international treaty with direct obligations towards corporate actors. So I would like to invite the debaters, Professor Julia and Bruna, to present their remarks and start the debate, as well as our participants that can open their cameras and microphone, or even present their questions on the chat so that we can read.
Thank you, Victoria. Perhaps I can start, Daniela. Laura, thank you very much. It has been a very nice presentation. I believe we can have a good overview of the main points of the draft. And I believe you have stressed some questions that remain open, and we still need to see how this, especially regarding the political process and negotiation, what will be the final instrument, and then we will jump to a different point, which is applicability and how that's going in practice. But right now I just have some questions that perhaps will help me understand better and the context. So what would be, because we are used to the UN guiding principles on business and human rights, we are used to deal with that, and perhaps you could explain a little bit more what is the potential relationship between what the UN guiding principle covers and the treaty.
Yes, so should I answer now?
I don't know, perhaps we can go question by question.
Okay.
Okay. We can manage the time. I don't know if you all allow this. Thank you.
So I think the main issue with the guiding principle was the difficulty of finding support for a binding instrument. And in this regard, some states were arguing that a binding treaty would be too vast. So that's why they advocate for a soft law instruments. And even John Ruggie as well has been very hesitant with the idea of a binding treaty. So the idea of the treaty is that soft law instruments are not enough, because we see that there are still many abuses committed, and there's not enough mechanisms addressing these abuses committed by transnational corporations. And, or for instance, also the idea that some states could not or are not willing or able to tackle these issues. So having a broader and binding treaty could have some advantages. In any case, both of them have the pros and cons. And the idea has been to continue with both of them, with both initiatives, the UN Guiding Principles and the treaty, in a way that they can complement each other. So, for instance, I don't know if this could be a good example, but the draft treaty talks about remedies before courts and before state-based non-judicial mechanisms, while the UN Guiding Principle also adds the possibility of a third type of mechanisms, non-judicial, non-states mechanisms, grievance mechanisms, those established directly by corporations. So I would say the idea, and this is, I think, the majority view, is that to continue with both instruments, with the idea to promote further access to remedies, and also to cultivate this idea of human rights due diligence of corporations.
Okay, thank you very much. We will go back to non-judicial grievance mechanism in a while, but let's go back a little bit and talk about political will. You have mentioned this in your presentation, and I will ask you if states are prepared to negotiate and sign the treaty, because you have mentioned that there are some states, the EU and perhaps others, that are more reluctant. So I would like you to perhaps explore this a little bit, and of course there is no certainty on what will happen, but your opinion about all of this.
Yeah, in fact, this is one of the main challenges, the lack of sufficient political support, including the European Union, but also other states such as the US, China, Russia, Brazil, Mexico, that have raised reservations about the treaty. And the US also said that this could not be one size fits all type of treaty. And the main reservation as well from the European Union has been that it is too vast, covering too many, a vast breadth of issues, both human rights, rights holders, and rights and duty holders, because it would consider all types of enterprises, while the initial idea was to only focus on transnational corporations. And however, there has been more awareness in the last years. And for instance, there is also a global interparliamentary network that has been created in order to support the binding treaty, and there was a resolution supporting the process. And there has been signed by more than 250 national and regional parliamentarians from around the world. And even some parliaments have also held sessions on the issue. And there was also a joint webinar last year in October with members of some regional and national parliaments from Europe, Latin America, and Africa supporting the binding treaty. So I would say it's still very divided on the supports. And in addition, if we look at the European Union, for instance, now they are adopting their own directive on human rights due diligence. So yes, this would be really a challenge. And as I said before, I think the idea is to finding a balance between a not very ambitious and comprehensive treaty that would not get the support of this kind of states, and then not being too general or too specific that it would actually not bring anything else to the table.
Okay, so just to contextualize for the audience, sometimes the draft talks about abuse and sometimes talks about violations. Are those the same to the same parties or targets, so to speak?
Yes, so the 2019 draft, if I remember, referred to human rights abuses and violations, and then the current version only refers to human rights abuses. And this is at the core of the issue on whether corporations could have human rights obligations and whether they could violate human rights, international human rights law. I think these different notions deal with the very idea of whether corporations are recognized at the international legal level, having international legal personality. So that would mean to only use the word abuse for corporations and violations for states. So I would say this is the main difference. However, in practice, sometimes it's difficult to make a clear distinction. And I would propose to talk about human rights violations also committed by corporations.
Me too. So another question is access to remedy and reparation. What is the potential of the already mentioned non-judicial grievance mechanisms?
Of non-judicial, you said?
Yes.
Yes, so actually this is one of the main research projects I'm developing at Nova School of Law, and it's looking at what could non-judicial mechanisms bring in relation to finding effective remedies for business-related human rights abuses. And I've been looking at the case of the OECD national contact points and the process of the specific instance processes. And there have several advantages. For instance, they could represent more affordable and accessible mechanisms for victims because they are less costly. They are based on mediation, so there are more possibilities to get corporations involved. And however, there are also many challenges, specifically on the effectiveness of these mechanisms. One of the main challenge is the lack of visibility of these type of mechanisms. For instance, I'm looking at the context of Southern Europe, where in Portugal and in Spain, there haven't been many cases before these national contact points. But I would say this could have the potential of having this mediation process, getting corporations and other stakeholders, trade unions, civil society organizations involved. The issue would be to really get effective remedies in the end by this mediation process, because sometimes the end result is that there is no agreement between the parties. But I would say this is a potential of finding remedies for victims as well.
Okay, it seems very promising indeed. So may I have ask the last question? Can I? Okay. So this, when I look at this draft, I see from a compliance program perspective how companies should organize themselves and analyze legal risks. This could be a really game changer in terms of human rights protection, because of the mandatory due diligence of supply chain, for instance, among others. But this is something that I question not only regarding human rights and also corruption as well. To what extent should we impose this kind of obligation? Because when we think about compliance programs, and as we call that ethics and compliance, we try to establish the link between values and compliance. So we need to go hand by hand, aiming at a more effective compliance program, ethics and compliance programs, so to speak, values translated into rules. So we need both. So do you think this kind of mandatory requirements could foster the right motivation? Because one of the risks is to end up in sort of a tick boxing approach. We do things because the law requires so, but it doesn't really change behavior internally. So I know this is a very philosophical question, but perhaps to have an idea, how could we take in these mandatory requirements and embedded some values in the corporation? Something that perhaps the guiding principles haven't been able to do so far, right?
Yes, I think this is actually a very key issue on whether corporation would just comply to, as you said, to tick the box, or for instance, to have some policy or some statement, but actually not really doing more than that. And probably I'm not sure about this would be translated into values, because sometimes companies would react if they have sanctions. But I would say during the last 10 years with the UN guiding principles, there has been more awareness on behalf of corporations about what are the things that they should do, and that not all type of conduct is permissible. And however, some of them, they still don't know how to do it, how to, for instance, conduct human rights due diligence. And so there is a mix of lack of sufficient knowledge about that. So I would say maybe this mandatory treaty, or for instance at the level of the EU, and this could bring more awareness and information about what should be the steps to be taken, for instance, to prevent potential or actual human rights impacts.
Many thanks, Laura, especially for the last question, because that is the conundrum, the compliance conundrum, if we say. So thank you very much. I hand over the floor to Daniela.
Actually, I do have a question, but I would like to have Bruna asking first, and then I can pose my doubts and also the other members of the panel.
Thank you. Hello, Lara. Hello, everyone. Good afternoon. Lara, thank you so much for your presentation. It's a pleasure to be here talking to you. I am very interested in this topic, so I have two questions. The first one is kind of related to the last question of Julia. We know most of the law is ineffective. It fails to hold companies accountable. So, how do you see that the social hazard caused by companies can be solved? If we think about the treaty, but besides the treaty in the real world.
I'm not sure if I understood correctly the question. If you maybe can repeat it or explain it again.
Okay, so besides the treaty, how can we hold companies accountable about the social impact, the social hazard that the companies promote?
Yeah, indeed.
How do you see?
Yeah, I would say that before the mandatory or binding treaty, the idea of corporations is the reputational costs that this could have. So sometimes they would look at this as one of the elements to act. And for instance, this has happened with some corporations causes damages in Africa where they did not provide any remedies. But in the end, because of these reputational costs, they were forced to somehow offer some kind of mediation or other type of measures. So I would say this could be one of the strongest elements, and not only about why they should comply, but I think this is mainly the basis of also corporate social responsibility or other types of frameworks.
Okay, thank you. About the remedies, actually, I'm very curious about this term, effective remedy. How can we describe an effective remedy? How can we point measures of effective remedies? So I kind of missed the data point of view, you know.
Sorry?
The effective remedy that you explained before.
Yeah.
How can you see measures to use the data point of view of what is an effective remedy in this strategy?
So the idea is based on the UN guiding principles. For instance, in relation, particularly to non-judicial remedies, but I think you can say it overall. There are a number of criteria that could tell on the level of effectiveness. That could be, I'm looking at non-judicial, so that's mainly what I was looking. And these criteria could be the accessibility, the legitimacy, and the predictability. So there are a number of elements that should be complied by different mechanisms to be considered effective. But in fact, this is difficult to assess in practice as well. How can you say this as being an effective remedy? And I would say there is also the idea of which forms of reparations are you providing? Because in some cases, the reparation that is offered is not enough for the victims. And I would say reparation should have a mix of material and immaterial elements. So considering, for instance, compensation, but also looking at other immaterial damages. That could be related to the element of satisfaction in public international law. And moreover, the change of policy of the company as a way to not committing the same things in the future.
Great. Thank you. Thanks so much.
So if I may, Laura and John, I'll pose a question. First of all, thank you very much, Laura, for the presentation. Thank you, Julia and Bruno, for the very interesting question. I have a question which relates a bit to, it's a huge concern actually in relation to the treaty that I have. And thinking about the treaty after it's already implemented, for instance, consider that it will be signed and ratified, and about access to effective remedy. My concern is in Brazil, we do have, in theory, a very progressive framework of substantive law to hold companies accountable, at least in theory. We have several mechanisms to support Brazil to get joint and severe responsibility of corporations. We have, in theory, several mechanisms. We have a strong prosecutor sector, etc. So we have some, in theory, our issue here in Brazil, it's both in relation to access to effective remedy in practice, because court process takes years and years and years and years, and then you cannot basically find actually a judicial remedy, and then there's also discussions between judicial and non-judicial, etc. So coming back to the point of in relation to the treaty, the issue that I have and the concern that I have is that what I see is in relation to access to effective remedy, what the treaty proposes is for countries like Brazil is not a bad new. What would be new and interesting would be, for instance, like the idea that we can do transnational tort litigation through waiving for non-convenience. But then I'm just asking myself, I mean, are we perhaps deeming ourselves in the global south to rely on national tort litigation and to get this access to effective remedy? What would be a potential solution? I don't see how much what the treaty brings to a country like Brazil, despite taking off the global element, considering that it might be effective in other countries and then due diligence and effective remedy in other countries happens, but I don't see how these actually is important for Brazil. So I just know your opinion, your views on this point.
Yeah, I would say that this have to do also not with a treaty on business and human rights, but in general with human rights treaties. And the key issue is on the implementations done by the state. And I would say if in the future there is any binding treaty on business and human rights, the idea would be to have a committee or human rights body who can receive complaints in relation to nationals' domestic situations, because the treaty is based on the obligations of states to really implement and adopt legislations on human rights due diligence or access to remedy and eliminate barriers for victims. And indeed, many countries would not be able or willing to do so. And so I would say the idea could be to have some kind of international body where some complaints could be filed. But again, I want to emphasize the idea of non-judicial remedies and the OECD as a potential forum to find some remedies. I was actually asking before whether, because I'm not sure whether Brazil was part of the OECD guidelines on multinational enterprises. So that could be another possibility. And of course, the problem is always at the domestic level with the jurisdictional issues and the parent company, and ideally it should be courts and judicial proceedings providing these remedies. But yeah, it's in practice, even in Western countries, still difficult to find remedies. So I would say this is one of the key issues in the field of business human rights, access to remedy.
Okay, thank you very much. João or Victoria?
Yes, I would like to present one remark. Thank you very much, Professor Laura. All the questions just make me think how complicated the subject is. So I would like to pose my remark in the international context. Europe now is experiencing the mandatory due diligence as well as Germany with the Lieferkettengesetz, the supply chain law. So one point that I have been observing towards the due diligence discussions behind the treaty here in Brazil and other countries is that, well, if we're going to approve an international treaty, we just don't need a domestic initiative of a national plan on businesses and human rights, for instance. This is the kind of point that has been on the top of discussions here in Brazil. So we struggle to have domestic initiatives, but at some point, we notice that the government uses the possibility of an international treaty as an element to delay the national discussions. So can we expect that the treaty, with its own limitations, can be the most efficient instrument to hold corporations accountable? And as a complement of a question that we have here on the chat from Ana Flavia, Do you have any comments on the German draft of the due diligence law?
Yes, so as you were saying, I wouldn't say that the binding treaty would be the philosophical stone that would resolve all the issues here. And this would have to be done with the progress, with the, I would say, at the domestic levels, at the regional level, how these instruments are really integrated into domestic laws. I don't think the treaty, if there is a treaty, could solve all these issues. But I would say voluntary instruments also have the potential to bring more awareness. And the national action plans is also a good way to somehow hardening soft law by introducing this type of legislative measures. So far, I think there are 24 national action plans worldwide. And I wouldn't say this is one way or the other. I think we should continue with all the possibilities at the same time. So the question that you raise as well is whether focusing on the negotiation of the treaty would actually diminish other initiatives that are currently taking place. And this is actually one of the concerns of certain states, whether some states would say, okay, I will rely on the treaty and then I will avoid my own responsibilities or obligations, saying like, okay, businesses have the obligations and not the state. So this has been also an argument on those not supporting somehow the treaty. On the German due diligence legislations, I haven't really looked at that. I think the only question that I remember that it would be based on corporations based or headquarters in Germany. So this maybe is a difference with other human rights due diligence legislation in other countries. And then I think it also includes criminal prosecution. I'm not sure. That is also another difference with other national initiatives.
Thank you very much, Laura. And I think we have another question here in the chat from Victoria. And Victoria asks about the corporate structures. She says that the corporate structure is often used as a means of ensuring impunity. For example, when multinationals allocate their resources in different jurisdictions to escape liability. So in this regard, do you think it would be appropriate for the treaty to deal in more detail with the disregard of legal entity?
Yeah, in fact, I think this is one of the key issues as well in relation to corporates accountability on the relationship between the parent company and the subsidiaries. And we have seen there have been many difficulties in some domestic jurisdictions to establish this link. I could say maybe yes, the treaty could actually establish or clarify it better what is the overall controls of the parent company over of the subsidiary and how this relationship should be better established for the purpose of funding liability.
Carolina, I think she would like to ask something also, please.
Yeah, can you hear me well?
Yes.
So yeah, first thanks for the presentation. And I'm hearing so lots about remedies and controls and everything, but something that I'm kind of worried about is the ethical impact of it all, because sometimes you see things where there are huge amount of legislation, huge amount of controls, just like social media today, but especially in UK right now. But somehow those data, they never come to transparency in themselves. We cannot control also. So we have a place where we have lots of legislation, but things don't work in a way or other. So I would like to hear from you. What do you think about that? What's your opinion about this? Very lots of legislative papers and everything. But in fact, when we don't have transparency and all that, we can have as much legislation as we can, but it won't work. So I would like to hear a little bit about that also, if you could comment.
Sorry, so your question was about the lack of transparency at
Yes, if there is something that says, for example, you have to take a report, an annual report and everything, because that's what was trying to do the UK. They say, okay, we have a lot of legislation already, but we have a problem of transparency, and we cannot just add more legislation if we cannot control what we have here right now. So yeah, just see if there is some kind of provision like that in this draft also.
Yeah, I haven't really looked at that. And I would say that the obligations of transparency or reporting, for instance, at the level of the European Union, was considered not enough to comply with certain requirements, although they are, of course, relevant. But yes, it could be a fundamental part on having more transparency. And you can also look at this from the perspective also of the OECD or other frameworks and the obligations of transparency on information. So yes, but I haven't really looked much at that point.
Okay.
So, Professor Laura, I think I don't know which time you have to leave. I think we have more 10 minutes, perhaps.
Yes.
Yeah. Yes. So I would pose just another question, that one regarding the Brazilian local context. Here in Brazil, we are facing a major increase in the spiral of victimization regarding business enterprises in the national regulatory and enforcement scenario. The agribusiness sector is linked with deforestation in the Amazon basin, and for this purpose of devastation, firms also use modern slave labor to clear space for soy production, for example, as well as the production and development of the cattle industry in the Amazon and mining in the region as well. In this context, not just the ecological heritage is being victimized, but also our native indigenous peoples that live in the region. So, in the regulatory perspective, the laws responsible for protecting the environment and the indigenous recognized territories are being rolled back, opening thus space for the development of harmful activities in the region, as well as for spreading COVID-19 to the indigenous peoples that live in the region. So I would ask, Professor, if the Biden treaty could address such a problem, perhaps from the perspective of the accountability enhancement within the business supply chains and the due diligence and reporting obligations deriving from the provisions of the treaty, since Brazil is a major exporter of food and commodities to Europe, China, United States as well. So how can we enhance regulatory certainty, legal certainty, as well as accountability in these supply chains, since the production, the supply is very displaced regarding the demand side. How can we enhance accountability and legal certainty in this context? So thank you very much for the brilliant presentation. Thank you also, Julia and Bruna, for the brilliant questions that you have posed. And that's the question. Thank you, Professor.
Yeah, it's a very challenging question. I'm not sure if I have the answer to that, to be honest. But in fact, I would say that the treaty also relies on the necessity to conduct human rights due diligence process, and these would relate to the four necessary steps on identifying and assessing the actual and potential human rights impacts, integrating, acting upon the findings, and communicating and reporting on how the impacts are addressed. And another improvement of the draft in relation, for instance, to indigenous communities has been the need for consultations with indigenous peoples in accordance with international agreed standards of free, prior, and informed consent. So this has been included in the latest versions of the treaty. So I would say this could serve as a very positive elements of the binding treaty. But in fact, it's, as I say, we are talking about whether and how can we implement, how can we find accountability, and in fact, I think it has to be the states really, states and corporations really understanding that they have obligations and responsibilities both to prevent actual and potential harms and also to provide remedies. And I would say even the UN guiding principles in the future would also have this idea of bringing more awareness, but we are still not there. And so I think there is a still long path towards finding accountability of corporations.
Thank you very much. Thank you very much, Professor.
So thank you very much, Professor Laura. Thank you also to Julia and Bruna for the very challenging questions that will certainly improve our understanding of the corporate obligations towards corporate actors and human rights. So it was a really great discussion that raised us very concerning points that we should talk more here in our national debates in Brazil. So in the name of the Business and Human Rights Working Group, I would like to thank you so much for the presentation and for your time. I just want to mention to you that we have a series of webinars going on, and we look forward to having all of you there too. And I would like to thank all of our participants to joining us in the second webinar too. So thank you again, Professor Laura.
Thank you again for the invitation. It was a pleasure, and I hope to be in touch in the future as well.
Certainly. Thank you. Thank you all.
Bye.
Bye-bye.
Thank you very much. Bye-bye.